Fantastic to have both of you here today. Thanks again for your time. We're obviously going to be speaking today about avoiding insolvency-related liabilities, and we have both James Fennessey from Scott Moncrieff and Iain Young from Morton Fraser with us today. So thanks to both of you for your time. We work with both firms in terms of our own audit and in terms of our own legal needs. So thank you again for your time. If people on the webinar want to ask some questions, there is a chat function at the bottom of the screen. If you want to ask some questions as we're going along, I will take a note of them and I'll ask them to either James or to Iain at the end if we have some time. So that is fantastic. I have some slides which I can power up. And Iain, James, you've spoken about the agenda and how you're going to break it up. I can hand over to you two.
Thanks very much, Kieran. My name's Iain Young. I'm one of the partners in the corporate restructuring and insolvency team at Morton Fraser. And I'm delighted to have the opportunity to speak to you today about some of the issues around insolvency from a legal perspective. So as Kieran said, if you've got any questions, please fire them in and I'll do my very best to deal with them at the end. And hopefully what I'm going to say to you may be of some interest. To start with, we're just going to have a look at the different types of insolvency. So perhaps the next slide, please, Kieran. There are two types of insolvency, and what I'm going to say here applies not only to companies limited by guarantee or companies which are limited by shares, but it also applies equally to SKIOs. So if you're a SKIO and you're the beneficiary of that regime, then this applies equally to you and your role as trustees as opposed to directors of a company. So what do we mean when we talk about insolvency? Most people think of insolvency as basically when a company runs out of money and it has to do something nasty with its business. Well, there's an element of truth in that, but actually the way insolvency is determined is in two different ways. There are what we call balance sheet insolvency, where a company's assets are exceeded by its liabilities. And there is also cash flow insolvency, which is the inability of a company to pay its debts as they fall due. Now, there is a difference in these two measures, and I'll explain later in the talk as to what the difference is and why it matters differently in different circumstances. So just moving on to the next slide, we're going to have a look at how insolvency law achieves its purposes. The basic principles are that when a company becomes insolvent and it goes into a formal process, then an insolvency practitioner, who is generally somebody who works for a firm of accountants, will take over the running of the company from the directors. The insolvency practitioner is under some general obligations. He's under an obligation to treat all creditors fairly and equally. The insolvency is not run for the benefit of the stakeholders at large, but is run for the benefit of the creditors. And the position of the creditors in terms of how much money is due to them and what their rights are is fixed at the point of the insolvency event. So that's the broad principle, but these are not inviolable rules. So depending on what sort of creditor you are, you may be better or worse off. So a secured creditor does not get treated in the same way as an unsecured creditor. And a receivership, which is a different type of insolvency from an administration or liquidation, is run for the benefit of a floating charge holder and not the creditors generally. There's also an arrangement called a CVA, or a company voluntary arrangement, where the directors remain in control, but they have to report to a supervisor who is an insolvency practitioner. But all of those principles, which I've just referred to above, are what underpin much of the thought and practice behind the law relating to insolvency. Next slide, please. So what sort of different types of insolvency regime are there? In Scotland, the most common types of insolvency regime are liquidation, which is the most common. There's three types of liquidation: compulsory, where the court orders that the company is placed into liquidation; a creditor's voluntary liquidation, where the process is kicked off by the creditors and they take control and drive the process; or a member's voluntary liquidation, which is generally where the company or the SKIO would be solvent. It's not an insolvency regime, and it's driven by the members of the organisation. Then we have an administration, which is where you've got a business which is capable of being traded going forward. A company voluntary arrangement. We've seen a lot of company voluntary arrangements recently, particularly in the retail sector, where shops are trying to, or chains of shops are trying to relieve themselves of some of the obligations to landlords, and they enter into an agreement between the company and all of its creditors. And part of that usually is a reduction in rents payable to landlords. And the landlords have the choice to either accept the arrangement or they find that notice is given under the landlord and tenant arrangements, and they no longer have a tenant and possibly premises which are quite difficult to re-let when there's no shortage of empty premises. Receiverships used to be quite common. They're now very rare, so I'll gloss over them. And then there was new legislation came into effect just a couple of weeks ago as a direct result of the, well, partially as a direct result of the coronavirus epidemic, but also because some of the insolvency regime was in need of reform. So there's a new moratorium, which I'll touch upon later, and a new restructuring regime. So on to the next slide, and we'll have a look at the new moratorium. As I say, this is a new thing brought in by the Corporate Insolvency and Governance Act. A company can apply to the court for a moratorium. During the moratorium, there is no legal process which is allowed to be taken against the company. So creditors cannot bring proceedings, suppliers cannot bring proceedings, customers cannot bring proceedings. Also, the company can't generally pay any debts that are due to creditors which were incurred pre-moratorium. The whole process is overseen by an insolvency practitioner, but the directors remain in control. So it's a bit of a hybrid, really. The insolvency practitioner is referred to as a monitor. The monitor needs to be constantly of the view that the moratorium is likely to lead to the rescue of the company as a going concern. Now, because this is such a new piece of legislation, we don't really know how that's going to pan out, but that's going to be an area of some focus over the next few months, I would imagine. To start with, the moratorium is initially for a period of 20 business days, but if the court or the creditors approve, it can be extended further up to 1 year. And there are certain debts which are excluded entirely from the ambit of the moratorium. So bank loans, any third-party financing such as factoring, HP, operating leases, they're all excluded. So people who have made those sorts of debt facilities available can still enforce those facilities, and they can collect rent, they can collect interest, they can call in the debts. We don't know yet, because this is so early, what the amount of likely take-up of this process is going to be. So that's the moratorium, and as I say, it's a bit of a cross between a CVA and a scheme of arrangement. So moving on, and then I think we'll move on to the next slide as well. One of the other aspects of when a company is technically insolvent is that if it undertakes transactions, it's possible that those transactions may be challenged by creditors who feel aggrieved. And this is one of the questions which we get asked most as lawyers. You know, is a transaction which has been carried out by a company or a SKIO capable of being challenged and overturned? And they're relevant for liquidation and administration only. So if you're going through a CVA or the moratorium or the new scheme, then they don't apply there. But there are generally three types of transactions which are challengeable: gratuitous alienations, unfair preferences, and certain floating charges which are granted when a company is insolvent. And the references in brackets are to the relevant provision of the Insolvency Act 1986, which governs insolvency law in Scotland. So why do we have these challenges at all? Because the challenge is because the acts carried out by the company offend against the cardinal rules in insolvency, which are to protect the creditors and give the creditors equal treatment so far as possible. So if there is a transaction carried out which reduces the value of the balance sheet or changes the order to the creditors get paid, that's deemed to be bad and therefore is challengeable. Next slide, please. The first of these is, if we could just move on to the next slide, please. Yes, thank you. Gratuitous alienations. this is where a company disposes of one of its assets, and it happens within 2 years of, or if the parties are connected, 5 years of it becoming insolvent, and it is effectively reducing the value of the balance sheet by taking an asset out of the balance sheet for less than full value. So if that happens and a claim is brought, then a company can try and raise certain defences. It can raise one defence that at the time the asset was transferred, it was in fact balance sheet solvent, or at the time the asset was transferred, the company received what's called adequate consideration. In other words, although the company may have been distressed, was the value paid for the asset a reasonable amount in the context of a distressed company getting rid of assets? So we're looking at the balance sheet there. Has the balance sheet been affected by the alienation of property beyond the reach of creditors? And then on to the next slide, please. Yes, this is unfair preferences. Now, unlike the gratuitous alienation, with unfair preferences, there's a 6-month look-back period, and even if connected parties are involved, there's no extended period for that. So this is where a creditor has been paid in preference to other creditors of the company of the same category. So if you've got 5 unsecured creditors and you choose to pay one unsecured creditor, but leave the other 4 unsecured creditors hanging out there without receiving money, then that could be construed as an unfair preference. Again, there are defences available to the company if that is alleged. And the first defence is that the transaction was in the ordinary course. The second one is that it was payment in cash for a debt that was due. So the debt was due and you weren't preferring one creditor whose debt was also due. So as long as the debt was due and payable and you pay it in the normal course, that's not a problem. If there were so-called reciprocal obligations, so in other words, if you paid the debt, then you got something back in return for it. And an example of that might be that if you, let's say, you need access to vehicles and there were sums due to the vehicle hirer, and you paid those sums, then the vehicle hirer would agree that he wouldn't take the vehicles away for you. So that would allow you to continue trading your business. And the fourth one is if the court has ordered that there be the payment of funds which had been arrested by order of the court. So that's a bit different from the balance sheet being attacked. What we're looking at here is a changing of the order of priority of payment of debts. So that's a change the order of priority thing. And again, we're looking at the question there of collusion. What's collusion? It's quite a difficult thing to explain. It's, you know, it's a bit like trying to describe an elephant. Quite difficult, but you know it when you see it. And basically, if you look at a transaction and you see that somebody's been paid ahead of the other parties and it's a bit smelly, then there's probably been some sort of unfair preference there. I wish I could be more precise, but that's also the way the courts look at it as well. If they don't like the look of something, then they might find that it's an unfair preference. Next slide, please. Yes, what we're looking at here is that if new security is granted to a third-party creditor of a company or a SKIO in circumstances when the company or SKIO is technically insolvent. So, in other words, I make money available to a company which is technically insolvent, and they grant me security over all their assets ahead of all their unsecured creditors. And I'm an existing lender to that company. So my position is being improved at a time when the company is insolvent. And again, there's a look back period if that's happened. It's 1 year generally, or if it's with connected parties to the shareholders or directors, then it would be 2 years. But if I'm making new money available to help the company through its period of distress, then they're entitled to grant me security, but only in respect of that new money, not in respect of the old money. So if the company can pay its debts at the time the money's made available, that's another defence available to it. And in terms of categorising that, it doesn't have an adverse impact on the balance sheet, but again, it's just a changing the order of priority of payment to creditors. So it's a type of unfair preference, but it's a specific type of unfair preference. So that's looking at challengeable transactions. I'm now going to hand over to James to talk a bit more about some of the accounting aspects, and I'll come back later and finish up with some more legal aspects. So over to you, James.
Thanks very much, Ian. So I'm James Fennessey, Director of Restructuring and Insolvency Department at Scott Moncrieff. So I'm delighted to have this opportunity today to speak to you all. And I'm going to talk about the warning signs of insolvency and the steps that you can take to avoid it. The first thing to say is that insolvency doesn't happen overnight. There are many warning signs that management receive which indicate that serious financial difficulties could happen if action is not taken. Being aware of the warning signs of insolvency allows directors, business owners and trustees to address those issues which may impact on the viability of their organisation. It also allows them to seek appropriate advice in a timely manner. In our experience, the earlier the action is taken, the better the outcome is for all parties. As the solvency of an organisation deteriorates over time, I have categorised the warning signs into 3 distinct groups. The first group is early warning signs. If recognised and acted upon, management give themselves the best chance of being able to resolve those issues threatening the business viability. These warning signs are commonly displayed by organisations as they begin to experience financial difficulties. The list is by no means exhaustive, but I have noted a few common early indicators of potential financial distress, which I'll now talk through. Firstly, direction of reserves. Are reserves being used up, and how quickly is this happening? How are reserves likely to move over the next 3 months and beyond? How does this compare to your reserves policy? It's critical that any analysis of this is split between restricted and unrestricted funds if appropriate. Accumulated losses. Is the organisation making losses or deficits year on year? What effect is this going to have on its available working capital? Occasional late payments. Management should be working with the finance team and asking themselves the question why this has happened. Is this merely a one-off, or is it indicative of the underlying financial position of the organisation? Increased use of personal resources. Is there a trading subsidiary or a business which is being financed by directors or a shareholder loan? Are personal guarantees required to obtain or support external finance? Is a charity even propping up its struggling trading subsidiary? Relationship with the bank. Is the bank taking more of an interest in monitoring the organisation's current facilities? Is there an inability to obtain mainstream finance? Has the organisation been declined finance by its existing banks, or is there little appetite from other main funders? Reaching credit limits. This applies to agreements with trade suppliers, but also providers of other external finance. If there is no headroom, then breaches of facilities may be likely if supplier credit lines are exhausted. So what impact is that going to have on the organisation's trading and future cash generation? Lastly, non-collection of debtors is a common issue for all types of organisation. If cash is tied up, payments to suppliers may have to be delayed, free reserves may have to be used, and more pressure is placed on other areas of the business. If debtors are not collected timely, the protection of bad debts increase. Before moving on to the next list, it is worth noting that these signs may not necessarily be indicators of insolvency, but they should be taken seriously and addressed early. The next group is substantive warning signs. As the financial position of an organisation deteriorates further, the threat of insolvency becomes more obvious, and it begins to have an increasingly detrimental impact on the business. These warning signs indicate serious cash flow issues which need to be addressed immediately. Firstly, is there an inability to obtain finance from alternative funders? Having exhausted all the options with your existing funder and other main providers of finance, it is common for organisations to approach alternative lenders who may be able to offer a solution. However, a lack of appetite from more uncommercial lenders or funders of last resort is often a key of the financial distress of an organisation. Suppliers placing the customer account on stop. This is a key sign of the goodwill with suppliers being built up over a period of time being exhausted. Alternative suppliers may be found, but the financial position of the organisation may make this a tricky exercise. Payment of rounded sums. It is common for organisations in financial distress to pay what they can rather than settle amounts due. Structured payment plans as part of tight cash control and robust financial projections can provide valuable breathing space for an organisation. However, if plans are constantly defaulted and revised, the underlying causes of this may require to be addressed. As you know, it is possible for payment plans to be put in place with HMRC. Indeed, in the current climate, there is likely to be more opportunity to engage with HMRC over existing debt and overdue debt. Certainly, HMRC will not be as aggressive as it was pre-COVID-19. However, that position will change. It is also worth noting that HMRC will have preferred status for some of its debts come December 2020. And please always remember that the debt will need to be paid back at some point. Lastly, statements, threatening letters, etc. are all signs of significant financial distress that need to be dealt with. Please do not ignore. These will not go away. If a number of these signs are identified, then it is likely that immediate action is warranted to ensure the survival of the organisation. Lastly, I've noted some critical signs, warning signs, sorry. At this point, creditors have lost patience, goodwill is exhausted, and critically, your options of extracting value and achieving a positive outcome are very limited. At this stage, advice from an insolvency practitioner or a restructuring and insolvency lawyer will be required. Next slide, please, Iain. Thank you. Now that we know what the warning signs are, the question is, what can you do to avoid insolvency? There is always a balancing act between tight cash management and trading insolvently. I know that Iain is going to provide some narrative on wrongful trading shortly. I always take the view there is nothing wrong with maximising your creditor days whilst there are cash flow pressures on the organisation, as long as there are reasonable prospects of a sustainable future trading. However, micromanaging your cash and not paying your suppliers is not a sustainable strategy. With this in mind, I have noted some areas which directors, management and trustees can take to avoid longer-term financial distress. Firstly, it is critical that timely and robust financial information is available to all stakeholders. Decisions on out-of-date information or inaccurate data result in poor judgment, wrong communications and further financial struggles. Those responsible for running the organisation or safeguarding its assets have a duty to ensure proper accounting records are maintained. Always provide the analysis of reserves between restricted and unrestricted funds and liquid and capital assets in every report to trustees and management. If the financial struggles of an organisation are identified and tackled early, there are always quick wins that may result in significant savings for the organisation. For example, is there any trapped cash and are there any options to release these funds? This could include excess inventories, motor vehicles not needed, surplus plants, non-critical subsidiaries and so on. The surplus assets could even be sold at discount rather than the unrealised value decreasing over time in the business. Can non-essential overheads be cut or deferred whilst the business assesses its cash flows? This could include advertising, business rates and surplus properties, property maintenance and non-essential travel. Finally, is it possible to resolve invoice disputes with customers early to release trapped cash? The next key area is cash management. You should prepare a rolling 13-week cash flow showing forecast receipts and payments that could be split as supplier payments and overheads, staff, utilities, rates, etc. The past week's actual performance should be analysed and investigated with the cash flows updated each week. This should be split between restricted and unrestricted reserves if appropriate. In respect of stakeholder management, you should detail a list of all stakeholders in order of priority impacted by cash flow issues, future or current. This should include shareholders, funders, customers, suppliers, and employees. You should set out an agreed action plan for each stakeholder, establish strict controls over payments to preserve cash reserves. This should have reference to non-routine and discretionary expenditure. This will buy time for longer-term solutions to be sought. You should concentrate time and resources on critical, larger suppliers than spend efforts in controlling the smaller suppliers who have less of a vested interest in the company's survival and less experience of a recovery from distressed situations. You should speak to your suppliers and customers so that you can smooth each other's cash flows if at all possible. And where possible, you should seek more favourable terms from customers and suppliers. Payment promises and plans must be achievable and honoured to preserve credibility. And finally, revise your business plan for the new normal post-COVID-19. In respect of the control environment, you should analyse cash control and impose strict controls over collections, payments and purchase ordering. Do not delegate cash control to lower level staff. You should raise sales invoices promptly and keep your accounting records up to date. Overdue accounts should be aggressively chased to improve liquidity, and opportunities for customer support by early payment discount or fast payment programs should also be considered. As a priority, you should do a forensic review of all processes that turn an order into cash across your business and make changes to improve efficiency and cash retention. Where possible, you should make use of automated software which interacts with your accounting system. You should also review all non-trading contracts, commitments that have a cash requirement over the months ahead and reconsider their necessity. Lastly, you should revise your inventory management strategy, consider minimum order quantities, frequency of orders, and match these to stock turnover levels. In respect to funding, has the organisation exhausted all possible COVID-19 support? Loans, grants, etc. Please do remember these loans do need repaid and should be included as part of any cash flows that you prepare. Alternative sources of funding or fundraising may bring in additional revenue to help insolvency. However, you must ensure that any additional funds raised are unrestricted to recoup losses for creditors. You should also consider discussing the finances with your bank/lender, particularly if secured loans are held against the charity property. You could also review existing borrowing or loan facilities or potentially seek new arrangements. Restructuring and turnaround. If the financial problems are identified and tackled early enough, it could be possible to reorganise the business. This could involve changing the business model for post-COVID-19 activity or working with other stakeholders to restructure your balance sheet. It may also make sense to seek a merger with a like-minded organisation. A restructure or turnaround doesn't have to be a formal, complex process. It could be a combination of the measures already discussed above. Finally, depending on the circumstances, an insolvency process may be needed. For example, this could help set up a more streamlined organisation post-COVID-19, which preserves employment, customer and supplier relationships, and so on. Next slide, please, Iain. Thank you. A key part of all the things we've discussed is to make sure you're getting the advice you need and when you need it. You should be constantly challenging your advisors to work with you to overcome any challenges the organisation faces. Some final thoughts. Due to COVID-19 and the relaxation of some of the insolvency provisions which Iain has talked about, there is time to formulate a plan, and it's always better to take control of the situation, because if you don't, someone else will at some point in the future. I will hand you back to Iain to conclude matters, and thank you very much.
Sorry, I think I was in mute there. So thanks very much, James. And I'm just getting used to this new normal, the new technology that everyone keeps speaking about. It's great to have the new normal, and great we can still communicate with each other in that way. One of the questions I'm asked about most often is, what is the potential personal liability for trustees of charities or directors of companies, and how can they make sure that they avoid any potential liability? And I'm sure that's something which is pretty much at the front of mind for quite a lot of the people tuned into this webinar. The provisions which deal with this under the Insolvency Act 1986 are collectively referred to as wrongful trading. Now, the most important fact of all is that we're asked about this an awful lot, but very rarely do we see cases in relation to wrongful trading actually reach the court. So, whilst in theory it's quite a high risk, it does depend on somebody being prepared to fund an action against a rogue director or against a director who they feel has misbehaved and who may be a useful source of recouping funds which have otherwise disappeared from creditors. So if you are involved in wrongful trading, then there is, of course, the risk of personal liability. And it's really just a statutory embodiment of the duty of the directors or the trustees to act in the interests of the creditors when insolvency threatens. And what is that duty? Well, the duty that's on the directors of the trustees is to do what they can to minimise the exposure of creditors. And if they don't do that, then they can be personally liable to contribute to the shortfall in the insolvency. And what's happening in this time of COVID? Well, the government has, helpfully or unhelpfully, depending on whether you're a director or a creditor, suspended the wrongful trading provisions. They may well be suspended until late July. That's the current thinking, but they may also be extended beyond that. And I think actually recently they were extended out until October. So, you know, there is this hiatus we're in currently where anything that you do or you don't do now cannot form the basis of a wrongful trading claim. However, that doesn't relieve you from your general duties as a director. You still have to, or as a trustee, you still have to comply with your normal duties as a director or a trustee, which I'm sure you're all familiar with. So when directors come to us and ask us about how they protect themselves, we have to have a discussion with them which asks them some pretty serious questions. And the first question is usually, is your company insolvent? And that goes back to what I said at the start. Are you able to pay your debts as they fall due? Is your company balance sheet insolvent? Are the assets of the company exceeded by the liabilities? And as James put it, it's important that you have up-to-date and reliable financial information to allow you to make that decision. Is it credible, accurate, and current? If you are clearly past the date when you have hit insolvency, the next question you need to ask yourself is whether trading can continue, whether it can be slowed down, or whether it should be stopped altogether. And what action should you be taking to minimise the exposure of creditors? Should you be looking at some form of formal insolvency, such as administration or liquidation? What's going to be best for the creditors in the circumstances? And if there is a case brought against you for wrongful trading, that's going to be brought effectively after the event. So it's important that you scribble down what you were thinking at the time you made those decisions. So record the decisions at the time in writing and record the reasons behind those decisions. And therefore, if you are on the end of a claim for wrongful trading, then you've got that audit trail, you've got that backup, and it shows what was in your mind when you took the decisions that you took. Next slide, please, Kieran. Now, this slide and the next slide are very, very busy slides, and I'm sure we'll be distributing the slides after the event, but I've highlighted in rather larger print the most important aspects of this. So you're only liable for wrongful trading if you knew or ought to have concluded that there was no reasonable prospect that the company, or in the case of a charity, maybe a SKIO, would avoid going into insolvent liquidation. And you as a director or trustee will be relieved of any liability for wrongful trading if you took every step with a view to minimising the potential loss to the company's creditors. So that's quite a high burden. You've got to have A, identified when insolvency has occurred, and B, you've got to take every step with a view to minimising the potential loss to the company's creditors. And next slide, please. This is almost impossible to read, so the following slides are going to take you through some of the things you ought to do. But when you get this pack sent to you, this will help you. This is one of the crucial slides to read, so read it at your leisure. But moving on to the next slide, here's some of the things you can do to reduce the chances of you being on the receiving end of a claim for wrongful trading. Regularly review the financial performance of the business and identify problems with ongoing viability early. If you click again, financial and management information, as James has said, should be up to date and accurate. And it's also got to be available to all directors, because when a claim is brought for wrongful trading, it's not against a particular director. It's not necessarily against the chief executive. It's not necessarily against the financial director, albeit that the financial director is probably the one who has the best handle on the finances of the company. Generally speaking, if creditors are looking to recover money from a company which has gone into insolvency and they're looking to the board to do that, they'll look at the person who's got the deepest pockets. And that in many cases could be one of the non-executive directors, because they have made money through their past business career and they have significant assets. And they may know actually very little about the business. They may have had very little involvement. But when a company becomes insolvent, it's really important that all directors start taking more of an interest in the business than they have to have done up until that point, because they are then potentially in the firing line. Next bullet, please. Yes, as James said, at the first sign of insolvency, seek independent advice on whether or not trading should cease. That should be either from an insolvency practitioner or a specialist insolvency lawyer. Next slide, please. And if you click on the yes, take steps to minimise unnecessary costs. James has touched upon that in quite a lot of detail. Again, consider reducing unnecessary expenditure. Keep bankers and auditors up to date. And then on to the next slide, please. It's really important that the board discusses this. There has to be a full board meeting called as soon as the financial difficulties are identified. And my recommendation is that you have frequent board meetings after you've identified that the company is in financial difficulty. They must be at least monthly. Depending on how critically distressed the company is, they could be more frequent than that. And at those board meetings, make sure that detailed minutes are taken of all the matters discussed and the decisions which are taken. And if any of the directors, next bullet please, if any of the directors don't agree with the decisions which have been made, those directors should ensure that in the minutes of the meeting, the dissents that they are, or the disagreements, or the way that they disagree with the decisions, that should be noted for their own protection. On to the next slide, first bullet. Review the responsibility of the directors within the company. There may be a non-executive director who's been through an insolvency process before, and therefore he or she may be the right person to take control or to step up to the plate and guide the company through this difficult process. It's important that not only do you get the correct management information in the accounts at the start, but that management information in the accounts continue to be made available and that they're properly and efficiently maintained. Talk to your creditors. They're the ones who are most likely to bring you down. Make sure you tell them what's happening. Make sure you get them on side to the extent possible. If there are compromises to be reached, then try and reach those compromises with your creditors. And if all of that fails, then consider applying for an administration order. Or if you have secured lending from the bank, invite the bank to a point. Generally speaking, banks, because of their own concerns about reputational risk, they much prefer directors to make the appointment than for the bank to make the appointment themselves. So the first thing they will do is they will say to you, go away and make the appointment yourself. But in some cases, they will make the appointment on your behalf. And then on the next bullet, what we talked about earlier, don't enter into transactions at an undervalue or prefer one creditor over another. If you're wanting to dispose of assets and you're not quite sure which assets to dispose of or which creditors to pay, take advice, again, from your insolvency practitioner or your lawyer. Maintain accurate records, next bullet point, thanks. Maintain accurate records of the actions and decisions taken by the directors, including any dissents. And if the rest of the board won't listen to you and you're a director, consider resigning in protest, but only do that as a last resort. Next slide, monitor compliance with financial covenants. This is very important. If you've got financial covenants in your banking documents, make sure that they are looked at regularly, and that if you identify problems, go and speak to the bank. So if you do all those things, the chances are that even if the company does go down and the company does lose money and creditors are out of pocket, then you will have a good defense if any creditor decides to bring an action against you as a director or a trustee for wrongful trading. Now, this is my last slide. I'm just going to touch on the new regime. I mentioned at the start that this is relatively new, only came into effect as new legislation a couple of weeks ago. It's the new Corporate Insolvency and Governance Act 2020. It introduces a couple of new structures and regimes, the moratorium, which we've talked about earlier, and the restructuring arrangement, which is a scheme similar to CVA, which is put to the creditors of a company and they are asked to give their approval to that. It's a bit like some of you may have heard in the US of Chapter 11. No one really knows how this is going to take effect in the UK. It's all very new and relatively untried, so watch this space. And then the temporary provisions, which deal specifically with the COVID-19 situation. Until September the 30th of 2020, there's been a suspension of wrongful trading. There is an effect on winding up. Previously, if a company was going to be liquidated, a winding up petition would be presented at the court. That's now been suspended until at least 30th of September 2020. No winding up petitions can be presented and no statutory demands can be presented other than ones which were in train before the advent of the new legislation. And then the last bit is, lawyers love to use Latin, and not least that the legislators love to use Latin. So this is what's called ipso facto clauses. And previously, you'll all have seen this in commercial contracts. There are terms in commercial contracts which say that if a company becomes insolvent, the supplier to the company is able to withdraw its services and terminate the contract. Now, it's still possible to have those clauses in contracts, and many historical contracts will have those clauses in them, but they have now become unenforceable with certain exceptions. So what that means is they've changed the playing field slightly, so it's a little bit more in favour of the company which is in distress, as opposed to the supplier to the company which is in distress. And therefore, what the government is trying to do here is give companies in distress a better chance of surviving and coming out the other side. And therefore, those clauses which previously allowed a supplier to withdraw their services or withdraw the supply of goods to companies in distress are now no longer enforceable. So that's a very quick thumbnail sketch over the new legislation and a very quick run through of the wrongful trading facilities and wrongful trading provisions. I'm sure there will be some questions which you may have. So I'll hand back to Kieran now, who will probably fire the questions at us.
That's fantastic. Thank you. There's a few questions coming in, a few about CVAs. One thing just to ask about in terms of mergers and potential options for companies. So we've got a session later on in the week looking at mergers of companies, and thinking about if a company is looking like it's insolvent and you're thinking about mergers, what are the kind of practical considerations maybe the senior company should consider when merging with a potentially insolvent company, and can they do that?
Shall I kick that one off, James?
Yeah, absolutely.
Well, I think the most important thing is that you do a little bit of due diligence in advance so that you don't end up adding 2 and 2 and getting 3.5.
Yeah. You
need to get at least 4+ for it to be worthwhile in the first place. And generally speaking, the reason you would merge would be to reduce overheads so that there's the same central office, so to speak, providing the same services to a larger business. And it's important that, you know, you make sure that as much as the two businesses may marry together, actually you're not going to end up with overcrowded management levels. So you should really think these things through properly. What's the correct structure going to be for the management going forward? Are you going to improve the finances of both businesses rather than just rescue one? And the third point really is, you know, is this something which is going to be viable going forward once combined, or are you just kicking the problem further down the road, and, you know, is it not properly thought through?
Thank you for that one. One more question. So there's a comment here. Interested in the ideas of speaking to suppliers to smooth each other's cash flows. Could you describe in more detail how this would work? I guess this is about being transparent, open and honest about the financial situation with your creditors, and that was something which we discussed earlier.
Yeah, you're very much so, and I suppose it's not always going to be applicable, you know, based on the relationships. I suppose it works best when you have a long-standing relationship, or indeed a valued relationship at both sides of customer and supplier, and there's mutual benefits to it. But it really is, it's trying to minimise the shocks, you know. So you've if you look at it from a sales point of view, you have did your sale when you wait for the funds to come in, but the credit terms come and go. It's minimising that, so it's kind of keeping close to the customers. And indeed, if there's suppliers of key goods that you need for your business, you know, it's building a good relationship there, that you can build that dialogue, so that if you do have potential financial distress, you can open up and have those conversations, you know, within certain parameters. And as I say, it's really just designed to try and protect your cash flow and stop any shocks and any nasty surprises.
And just to add a bit of gloss to that, I mean, James mentioned when he was talking to the audience about, you know, early intervention, identify these things as early as possible. And whilst in the long run, people may think that, you know, if a company goes into some sort of formal insolvency, then lawyers and accountants make more money out of it that way. The reality is not the case. You know, we would much rather have lots of healthy, thriving businesses who can, who require legal services and accounting services going forward, than waiting till the very last minute when, you know, the options are closed down and there's very little we can do. We'd much rather help a business grow, rebalance, and continue to contribute to the economy, rather than wait for it to be, you know, almost drowning.
Correct.
Absolutely. One more question on, or just to confirm, I guess, and you made the point that directors are, or company directors are equally liable, and I guess that's in charity law and in company law. So, for example, if you have a director who is a finance specialist, like you said, they might be a specialist, but they are no more liable than any other director within the company or the scale.
Yes, that's right. I mean, ultimately, if creditors are out of pocket as a result of what they believe to be misdemeanours by the company or the scheme or the charity, then they will seek to get compensation from whomsoever is able to make that compensation available. And whether you have a specialist skill set or not, all directors at law are deemed to be equally responsible for the affairs of the company. Now, there's a slightly higher obligation upon finance directors, but the fact that you turn around and say, I never looked at the finances, I left that to the finance director, well, that's just as negligent as the finance director not doing his job. So, you know, you can't wash your hands of liability simply by saying, I never asked any questions.
A question on CVAs as well, because we've seen within over the past couple of years or so within the retail sector, as you mentioned, with CVAs, that they can be quite commonplace if there's an agreement that's met with all creditors. It's probably a bit too early to ask this question at the moment, but there's quite a few of social enterprises within Scotland or the UK that run cafes, or they run maybe shops, charity shops, for example, for charities. I guess CVAs are probably, I'm assuming, more kind of prevalent to date within the retail sector, sorry, within the commercial sector, because it's generally quite large retailers that we've seen go through these kind of processes. Are there any kind of thoughts on whether CVAs and this type of action may be seen more when we have maybe retailers who have the same rents for shops, but you can get less people or fewer people into a shop because of social distancing and so on? Just quite a long-winded question, but just your thoughts around about the kind of predictions of the high street, of town centres, of retail, and potential impacts on the third sector.
I'm happy to kick that one off. One of the problems with the CVA is it was a piece of legislation brought in by government with big businesses in mind. And unfortunately, quite a lot of what the government does is with big businesses in mind. And the problem we face is that, particularly in Scotland, there's a lot of businesses which aren't actually that big, but they make a very valuable contribution to the economy. And something like a CVA isn't really designed for those sorts of businesses, unfortunately. The production of the CVA scheme document is quite a lengthy and expensive process. You have to appoint a supervisor under a CVA who will require to be remunerated from the proceeds of the CVA. So unfortunately, it's not really the right tool for fixing problems with smaller businesses. If I were running a cafe, and tell you what, at the moment, I'd quite like to be running a cafe and see some human beings rather than sitting at my desk all day. I think if I was in financial distress, I'd be going off and trying to have a sensible, constructive chat with my landlord, and putting the points across that you as the landlord, you've got a choice. You can either accept reduced rent and continue with somebody as a tenant, or I'll just give you notice to quit. You'll have an empty building there, and unless you've got a stream of tenants queuing up to occupy that space, please, it makes sense that we do some sort of deal.
Yeah, I would agree with that, Kieran. I've never been involved in a CV in Scotland because they tend not to happen that often. As Iain says, I don't think they're appropriate for a lot of the organisations we come across. I think there is scope, given the relaxation of some of the insolvency rules, for it's almost like an informal CVA, whereby you can have those conversations and that dialogue with the landlord and whoever are the main stakeholders, and you can work out a less formal process. But, I think it's a CVA. I think you read them in the press, but I don't think they're necessarily going to be prevalent in terms of the most of the stuff that we do.
Thank you very much. And there's one final question here, which is quite specific. And I should say, I should have said at the top of this webinar that all of this advice is given as non-reliance, obviously, and we would advise anyone that's in a situation of being a director or in control of the company who has any concerns to contact their accountant and then also a legal professional. But the question is, if directors' negligence led to the financial conditions requiring insolvency, but the responsibilities to creditors were fulfilled from that point forwards, is there a potential liability for those directors?
That's quite a tricky one. It would, and you're not going to like the answer, because I'm going to say it all rather depends upon the circumstances.
Absolutely. And
that sounds a very lawyerly answer, and I'm not trying to avoid the question, but it's sometimes quite difficult when you're going through a dynamic situation to determine exactly what it was that caused the company to become insolvent. it's much easier with hindsight. And when the courts review actions for wrongful trading, they will try and take a snapshot of what was going on at the time the actions were taken, rather than look back with hindsight. But, you know, if somebody has been negligent and that has resulted in some small way to a company becoming insolvent and the directors, and the creditors suffering losses, then let's not forget that there's also the general duties of directors as well. You know, just because you're not insolvent doesn't mean you don't do any duties. There are a whole host of duties set out in the Companies Act to, you know, to act fairly, to take cognizance of the interests of stakeholders, to act in the best interests of the company as a whole. And it may well be that the creditor who can't hang his hat on a wrongful trading action could possibly hang their hat on a different type of action. So just because the company is solvent, don't think it's a breeze. You still have all those other obligations as directors out there.
That's fantastic, and thank you very much. It's brought us up to time today, and we will share the slides from today's session if that's okay with both of you. Many thanks, James and Iain. Thank you very much. As we said, you're both our auditors at Social Investment Scotland and our lawyers, so we really appreciate the time that you've taken to go through all of these steps. Again, as we would advise, this is all kind of non-reliance advice, so if you do have any concerns, the first point of call should be speaking to your accountant, but then also there are organisations like Moncrieff or Morton Fraser that can provide expert advice. So thanks to both of you. Thank you very much, and I'll hope to speak to you soon.
Pleasure. Thank you.
Thank you. Thanks very much, everyone.
Thank you. Bye-bye.
Bye-bye.